Joining us right now is Ken Klukowski. He joins us to talk about yesterday's Supreme Court decision. Ken, we've had you on various times in the past to talk about what the Supreme Court might be doing, what they might be thinking, where they're going on some of the more controversial topics. And I guess we need to know, in your perspective, what did the Supreme Court do yesterday and why?
Well, thanks for having me, Larry, and thank you too, Brian. What the Supreme Court did in, of course, the big gay marriage cases that everyone is talking about, it's a scenario many people were not necessarily looking for. First of all, regarding the bigger case, potentially was the big California Prop 8 case. That turned out to be much narrower in terms of its scope and importance. And what went on with Prop 8 is that the U.S. Supreme Court held 5-4 that the challengers to California's Prop 8, defending marriage in that state as a man and a woman, that the official sponsors lacked standing to appeal the judgment of the lower court, both to the U.S. Court of Appeals, to the Ninth Circuit, and then eventually to the Supreme Court. In other words,
but Ken, the reason we got there is because, in 2008, the people of the state of California voted on this based on a statewide ballot proposal. They voted in favor of keeping marriage defined traditionally. When the court fight came about, the governor and the attorney general of California, Democrats, decided they weren't going to defend the decision of the people of California. Isn't that how we got there?
Exactly right. You had the plaintiffs who sued the state, meaning, of course, through the governor and AG. They refused to defend it. You had a judge, a judge who, after he decided the case, then openly came out and said, "And I'm gay, and I'm considering marrying my partner." So that there was even a little bit of a personal stake involved there that led one side to ask for his recusal, but he refused to. That you had Prop 8 struck down by this openly gay judge as unconstitutional. What the Supreme Court said is only, even though they chose to support the other side, regardless, the governor and attorney general were the only ones who could decide to appeal from that judgment. So when they refused to do so, and the proponents' official sponsors came in and took up the legal defense, the Supreme Court said they never had standing to take that case up to the Ninth Circuit Appeals Court, and they don't have any standing to bring it to us. Neither us nor the Ninth Circuit ever had jurisdiction. We're wiping all that from the books. We're vacating those opinions, and we're leaving this district judge's decision, which covers just one part of California, in place. So gay marriage is the law in either that part of California, or really, since it was suing the statewide officials, it means statewide in California. But it was not the big national ruling to create a constitutional right to gay marriage that the lawyers on this case pursued.
We're speaking to Ken Klukowski, constitutional lawyer at Liberty University School of Law.
Good morning, Brian.
Let me ask you this, on the DOMA case. As I understand it, a lot of people are going to look at this and they're going to come to a more simplistic conclusion that gay marriage is now legal. And that's not what this was about. As I understand it, in the DOMA case, they simply said that gay couples married in states where it is legal, and there are 13 states and the district where it is legal, must receive the same federal benefits when it comes to health, taxes, Social Security, et cetera, that hetero couples now enjoy. Can it be used to go larger than that? Because the president this morning is saying in an interview that he believes that same-sex marriages performed in one state should apply in another.
Well, Brian, you're right on all counts. I'll finish up on Prop 8 by noting there is actually a provision of California law that says no California public official can regard any enacted law in California as unconstitutional until an appeals court orders that. So there could even be a separate lawsuit that it might be resolved within just weeks or months, but it could be another year perhaps before even Prop 8 is actually struck down in California. Under the California Constitution, it is actually good law until an appeals court, not a trial court, even a federal trial court, says anything to the contrary. But then again, if those California officials abided by the Constitution, we wouldn't have had this lawsuit to start with. Now over to the DOMA side. That's exactly right. Section 3 of DOMA was struck down, and that only pertains to the definition of marriage for purposes of federal law. Section 2 of DOMA is the big one, and that says if you have a gay marriage in one state, no other state is bound to recognize it. Each state gets to
But that's not what the
themselves.
president is suggesting he would like to see this morning.
That is exactly right, and the president, once again, is kind of at odds with the U.S. Constitution.
Does this case...
we should give him points for consistency.
Well, does this case, however, give those who want to see gay marriage, embraced by all 50 states, does it give them a wedge, a way to work the issue forward?
It really does, Brian, because I was surprised. As a lawyer on this litigation, I was surprised that Justice Kennedy went as strongly left as he did. I respectfully but sharply disagree with him. He didn't use any sort of federalism rationale for what he was doing with DOMA, saying, well, the federal government shouldn't be involved with it. That's what he said during oral argument. It's not what happened yesterday. He signed on with the liberal justices to say on a broad base, he said these laws act to demean and degrade our fellow citizens. It acts to injure them. They serve no legitimate purposes. And he just goes on on this. That's the kind of language you use to create a broad-based right. I have to say, if they had found standing in the California Prop 8 case, I'm now not sure what way that court would have gone with Justice Kennedy feeling as strongly about this as he did. Given what he said yesterday, it would be a very natural follow-up lawsuit for someone to file today, or even the ones that are already in the pipeline, to say, well, what he said about DOMA Section 3, that also applies to DOMA Section 2. So I wouldn't be surprised if you have, for example, a New York gay married couple that now moves to Alabama or Texas, demands recognition and is denied it, brings a lawsuit under the big part of DOMA, and in front of the current Supreme Court, I think there's an awful good chance they would win. The takeaway from that is it means this was a 5-4 decision on all counts. It means the Supreme Court is in the balance for the 2016 presidential election on this and any number of other social issues.
Well, and listen, that leads me to my last question here. Ken Klukowski, and he is a Breitbart News contributor. You can check all of his stuff out at his byline there at Breitbart. He covers all of the Supreme Court decisions, and there are a lot of them this week. Here we are in the District of Columbia. We're straddling the two states. Couldn't be more different, Maryland and Virginia. Maryland, same-sex marriage is legal. Virginia, it's against the law. A couple who lives in Virginia, they're a same-sex couple. They're married. They want their gun rights, so they move to Virginia. Now what do?
Well, and in fact, that's what we're facing. And I'm glad you brought in the tie. Whether it's gay marriage, whether it's Obamacare, whether it is gun rights. The reality is that we have a written constitution for a reason. It is so that judges can only act to invalidate the actions of we the people when we put something in the Constitution authorizing them to do so. If we don't put something in the Constitution, then it's left up to the people and the voters through their elected leaders to decide things. Over this past week, affirmative action, the 14th Amendment says that the government cannot discriminate on the basis of race. And that is why the Supreme Court moved in just a baby step the direction it did on affirmative action. Yet the White House decries it. So did Eric Holder.
Right. As well as the Voting Rights Act. Hey, Ken, we've got to leave it there, but we want to. I appreciate it very much. We got to open it up.